We'll now move to the New Zealand Law Society, assuming they're online. No, good morning, Gareth. Appearing on behalf of the New Zealand Law Society. Thank you for appearing for the committee this morning and coming on a little bit earlier. Look, we have 10 minutes with you this morning. The time is yours. If you have any time that you wish to leave for questions, please feel welcome to do so.
Thank you, and thank you to the committee for the opportunity to submit this morning. You have a brief submission from the Law Society in writing. So what I was proposing to do was just speak briefly to two main points for making the submission, and then try and leave a little room for questions at the end if there are any. So I think the first question, or the first query that the Law Society has with the bill is the broad issue of retrospectivity. So when the Law Society sees retrospectivity, that usually invites an inquiry at its end, because it's not typically something that you see in bills, especially in this express manner. And that's not a concern that just the Law Society has, that's a concern that LDAC typically has as well. There's a lot of material in the guidelines from LDAC on when retrospective legislation should be used and can be used. And if I might summarise it, I think the general consensus is if it's going to confer a benefit, that's okay. But if it's going to impose a detriment or take something away from someone, then that's something that there really does need to be quite a strong set of reasons and good reasons in order for that bill to proceed. So when we look at this bill, we see a bill that does impose a detriment on people, because if you look at the existing state of the law following the High Court decision last year, there are people who do not owe a debt on supplementary assistance because of that decision. And this bill will mean for a lot of those people, they will owe a debt because it will overrule that High Court decision from October last year. And if we look at the reasons that we can see that have been put forward, we can see two reasons that have been put forward, it seems. One is cost, and the second is consistency with understood policy. And if we deal with those reasonably briefly, I mean, on cost, there are some figures in the legislative disclosure materials, which members of the committee will have seen. What the Society would really invite there is for the committee to closely scrutinise those figures, to talk to officials about what degree of checking and cross-checking has been done on those figures, because a lot of weight seems to be placed on those figures as a reason why this bill should proceed with the retrospective elements that it has. I think on the second point, the basis is essentially that the decision from the High Court is at odds with policy and understood policy at the Ministry's end. And really that's quite a sort of curious justification for retrospective legislation, because it really invites the question of, was the policy right and the law wrong, or was the law right and the policy wrong? And what we have here is a High Court decision which very clearly said that what the Ministry was doing in terms of recouping supplementary assistance was unlawful. We also have a position where the Ministry could have gone to the Court of Appeal through an established appeal pathway, but hasn't taken up that step and instead has gone down the road of retrospective legislation instead. So that's what we'd make on point one, is are the justifications for retrospective legislation here sufficiently strong to meet those LDAC guidelines and to meet the kind of class of legislation where retrospectivity is okay. The second point is a narrower point on retrospectivity, which is this. The bill before you does acknowledge that if it was completely retrospective, that would be unfair, because it shaves one rough edge off the retrospectivity and says that if you are a person who is either before the Social Security Appeals Authority or before the court, then you get the benefit of the old law. You get to rely on B and the decision in the High Court. But the Society thinks that the committee could go one step further on that, and that there is a important but minor change that can be made to the bill to increase the class of people who aren't affected by retrospectivity, and that's people who have already started the process with the Benefits Review Committee. And I think the committee's already heard a lot from people inside the industry about the theory and practice of that committee already this morning, that in theory it should be a prompt process which will allow someone to go to the authority and appeal afterwards, but in practice it perhaps hasn't been as quick as you might like. And so what that means is that there will be, what we suspect, and we suspect the committee can get figures from the officials on this, there will be a large number of people who are at the Benefits Review Committee stage who, under the current bill, will be forced to live under the new law. But if the committee was minded to make a change to this bill, or recommend a change to the House to this bill, they could be included in the class of people who are able to rely on B, who are able to rely on the old law. The current bill says if you are before the authority or the court, you get that benefit. We think it could be a very easy change and a very just change for the committee to recommend that people who have taken the positive step of going to the Benefits Review Committee should also get the benefit of that protection. So I'll just leave it there and invite any questions.
Thank you, Gareth. I think first question was from Maureen.
Thank you, Mr. Chair. Thank you, Gareth. Just want to explore a bit further that extension to include those who are seeking the review. At what point do you consider that they've triggered that process? Because, you know, from other submissions, we've also heard that it's quite difficult to get through that process and can take quite some time for some people. So where would you see this, the sort of cutoff point being?
Yeah, so the society recognises the difficulty of kind of having, I guess, a bright line there. And so what we've recommended in our submission is it's if you have actually made the application to the Benefits Review Committee. And that is a process that officials will be able to tell you whether or not someone has very clearly done that or not done that.
Okay, so that would be that would be a formal. Okay, thank you.
Yep. So you'll be able to see that very clearly. We're not suggesting in the submission that people who haven't gone to that stage of making the application would be covered by the extension.
Okay, thank you.
Great, thank you. Next question, Helen.
Thank you. We just heard from another submitter that there have been delays in reviewing decisions before this, and that seems to go to your point. Those people, would they be in that category?
Yes, I mean, I think so. As I understand it, and I'm not in the industry, and so we've had to rely on some information we obtained for a previous bill when we submitted on the Social Security Amendment Bill in 2025. At that stage, the information we were able to obtain, which was actually from I think a member of the public's OIA on a public site, was that there were delays with people who had taken the step of filing an application for review, but then found those review processes at the ministry and just not moving at all, or moving extremely slowly. So I understand there are probably also people from hearing some of the submissions this morning who have not even got to the stage of making an application, and that will be for a variety of reasons, I'm sure. I guess from the society's perspective, we were looking for a way to assist the committee with an easy fix. I have no doubt there will be people who won't have got to the stage of making the application, and there will be good reasons why they have not done that. I suspect it's quite a hard legislative drafting exercise to capture those people. So we were looking at a way to expand the class of people who are protected by the savings clause in a way that is easy to implement, basically.
Thank you.
But acknowledging that even that may cause an injustice, and that really means you should be looking at, do you need to make it this retrospective at all?
Thank you.
Thank you. Next question, Willie.
Thanks. Can you just give me a response, Gareth, to the allegation of double dipping? What's your response to that?
I mean, first of all, it's only covering double dipping on the supplementary assistance side, because the legislation in the High Court says it's okay for main benefits to be, I'll call it, clawed back. I don't think the society is probably the right person to get any information or advice on that point, because I think you'll get better information from people in the industry who will be able to tell you about the personal circumstances. We don't typically take a role on individual cases. We're trying to sit a little bit high above that. But I have heard some submissions this morning which make reasonably compelling cases as to why those people won't feel like they're double dipping. And that probably goes to the point about a retrospectivity and you getting some information from the officials about, do you really need to make this retrospective?
Thank you. Next question, Ricardo.
Thank you very much. Just from what you know in terms of experience with ACC claims and advocacy around that, would it be correct to make the assumption that most of the ACC claims that take a while to process tend to be on quite sensitive issues? And if you have any experience or commentary in the sort of demographics that do tend to take a while to go through the ACC claims process, would you be able to comment, please?
Look, I'm only here from society really, and I don't personally have much experience in any areas, but I don't feel it's something I can assist you with. So I don't mean to be unhelpful, but I think you're probably better to hear from people in the industry on those points.
Thank you. I'll catch you.
Excellent. Oh, look, thank you very much.
So, what's your 2 cents worth from that particular one?
I think I'm quite neutral on how the New Zealand Law Society did it, but so far, what the New Zealand Law Society should have done is like the way they stayed neutral in that bill. I find it quite concerning because at this point the bill should be either get rid of it because the bill in its current form shouldn't even become law. It just shouldn't.
Yeah.
And
The process to actually put in a review decision is not transparent. If you put in a complaint, or you don't even get a confirmation to say, we've received your complaint. You've just got to hope it's been received. And often when you sit there and put a review of decision, I don't want to sound derogatory here, but Floozy, who thinks she spends more time filing her nails than doing her job, might just sit there and put it in the pile to sit in the back of there, and the pile doesn't get processed. Because filing your nails is a bit more important than sitting down there and making sure someone who had been wronged gets the opportunity to get it to be made right. Thank goodness, I hope there are no floozies from the who like to file the nails who work for Work and Income. And if you are one of them, I'm sorry that you've offended you. But can you please stop filing your nails and start filing the paperwork? Yeah, it does highlight the problems with the systems with MSD because I remember one situation where I had a wrongful deduction made. It was Freda taking them to the High Court was what bucked them into action. With the word saying on there, once this goes to the High Court, don't bother trying to negotiate with me in it. You can negotiate with the judge. And you can explain to the judge why it's at the High Court. And, I've never seen Work and Income move so fast. I think they were faster than a tax order from the IRD when a threat had been taken to the High Court got mentioned. But the stupid beneficiary shouldn't have to threaten the High Court for due process to occur. Yeah. Okay. Now, the next up is John Miller Law with...
Are you ready for the 20 Renaissance general election? It's in the Ballot Productions presents Bringing Kiwis Election 2020 Sucks. Covering electorates from Cape Reinga in the north to Stewart Island in the south and everywhere in between. And available not just in your community hall, but also to watch from the comfort of your own home. Watch live and watch later. The way of accessing us is limitless. Let's It's in the Ballot bring you election 2020 sense. Your candidates. Your questions. And your answers.